Good morning and welcome to this session of the live coaching classes conducted by the Board of Studies of the Institute of Chartered Accountants of India. Just give me 1 minute before I go to the query pad and I will load the query. 1 minute. To do this. In the last class, we finished indemnity guarantee and we moved on to something called bailment and pledge. Okay. We also completed bailment and pledge to an extent. We could go in and we spoke about what is bailment. We spoke about the rights and duties of the Baylor and Bailey. Today, I have a real challenge because, and I wish all of you good morning, whoever is here, I wish you all good morning. And I have a challenge today. It's a huge topic. I don't know how I'm going to complete it today. So let us hope. And whatever happens, let us take a call. Therefore, I may not be able to take questions as and when. I will come to one point in time when I will go for questions, right? So we saw what is bailment. We saw what are the duties of a bailor, right? And we also saw what are the duties of the bailey. I think we went through all this. Then we saw the rights of bailor. See, every duty of the bailey would become a right of the bailor. And by the same token, every duty of the bailor will become the right of the bailey and a few others. Okay. But mainly, whatever the bailor should do, the bailey has the right to. Similarly, whatever the bailey should do, the bailor has a duty. Right. So, we saw all this. And one of the important duties of a bailey, right? Not to mix and all, but to take reasonable care of the goods. Very important. He must take as much care of the goods bailed to him as a man of ordinary prudence would under similar circumstances take of his own goods of the same bulk, quality and value. Bulk means here quantity. The word bulk here means quantity. Don't get confused. Bulk means quantity. This is the actual word used in the WAR Act, but basically it means quantity, quality, and value. That's all. Okay. So this is one of the important duties. In fact, failure to do this is a major issue. You have to take not just a care, but reasonable care. Okay. Friends, just give me 1 minute because I'm having a slight issue here. Allow me to. The connectivity. Dhyanam on the 316. 316. Just give me 1 minute. I don't know what's happening here. Anyway, so we saw the rights of bailey, etc. Now we go on to a very important topic, which is right of lien. Okay. L-I-E-N. Hope you will remember the spelling. It's L-I-E-N. Okay. There are two types of lien. Okay. There are two types of lien. What is lien? What is a lien? Basically, Lien, lien, is the right of retaining goods against any amount due. Okay? Right to retain goods against any amount due. So lien is available for many people. It's available to the bailee also. Bailee has the right of particular lien for payment of services. Now, when the bailee is entitled to a payment, then if that payment is not made, till that payment is made to him or the payment for services is made to him, bailee has the right to retain or right of lien. So, where the bailee has, but he should have done all this. He should have acted in accordance with the purpose of bailment. He should have rendered a service involving the exercise of labor or skill in respect of the goods. So he should have done these three things. He should have acted in accordance with the purpose of bailment. He should have rendered a service involving exercise of labor or skill in respect of those goods. Now, in the absence of contract to the contrary, please note it. In the absence of contract to the contrary, he has the right to retain, that is the right of lien, right to retain such goods until he receives due remuneration for the services he has rendered in respect of them. It's a very simple concept, easy to understand. You give your, or Mr. A gives some suiting material to the tailor for making a suit. The bill for that is 7,000 rupees. Now, A wants the suit. Now, in the absence of contract to the contrary, unless he pays 7,000 bucks, the tailor can say, I will not return the suit, I will not hand over the suit. So, does it satisfy all the conditions? What was the purpose of the bailment? To make a suit. Was it done? Yes. Is the suit in order? Yes. Is it usable? Is it as per the requirement? Yes. Take. Has he rendered a service? Absolutely. It's a exercise of labor and skill. And was it in respect of the goods? Yes. The goods bailed were the suiting material. He has done it in respect of the goods. He has to be paid 7,000. If he is not paid, he can retain until it is paid. Right of lien is only the right to retain and not to sell it. He cannot do. He'll keep it. And the service must have been entirely performed and the remuneration must have become due. Suppose the suit is not properly tailored and it is not, done in accordance with the contract, then he has no right of lien. This is called right of particular lien, also known as specific lien. Right of particular lien, also known as right of specific lien. The right of specific lien shall be available only against the property in respect of which skill and labor has been used. Very important. Suppose the bailee has other goods for which no services have been rendered. Maybe it is with him for safekeeping. Now the right of lien will not extend to those goods in respect of which skill and labor has not been used. So only those goods on which skill and labor has been used will be right. So I gave an example of a tailor. This is an example of a jeweler. So a diamond is delivered to him for cutting and polishing. It's accordingly done. Now he can retain the stone till he is paid for his services. Again, the example I gave is also here. Okay, simple as that. But then two things you should understand. Right of lien is the right to retain and not to sell. And bailee has only particular lien against only for the payment of services and only for the goods in respect of which the service has been rendered. Now there's another type of lien called right of general lien. Okay. Now the bailee, in the absence of a contract, normally in a contract of bailment, there is no general lien. I repeat, in the absence of contract to the contrary or in the absence of an express contract, there is no general lien. Bailee does not have general lien. Okay, normal bailees do not have general lien. That is, he does not have the right to retain any goods belonging to the bailor. He does not have. See, that's what I said. Suppose there is more than one, more than one set of goods. Some of which I have rendered skill and labor, others I have not. Or I have not rendered any skill or labor, but goods are with me. Can I retain? Yes. Few types of bailees can retain. They are without even an express contract. Impliedly, they have the right of general lien. They are bankers. A banker, for example, you give something to the banker for safekeeping. Some money is owed to the banker, then he can extend the right of lien on any goods belonging to the bailor. Okay. So, also factors, right? Wharfingers. Factors are those, see, a factor is a broker. It's a kind of broker. Okay. Factor is a kind of broker. He is entitled to commission. Suppose goods are in his possession. Okay. Then he can retain for his commission. Okay. Wharfingers are people who have warehouses near the port where goods are stored, either on receipt or before shipment. So these wharfingers also have the right of general lien. Attorneys of a high court have the right of lien, okay, where their fees is due from the client. They can retain any goods belonging to the bailor, right? Many times some goods are kept in the custody of the advocate or attorney. He can retain it pending payment of his fees. Insurance policy brokers also have this right. All of them are entitled to retain as a security for a general balance of account any goods bailed to them in the absence of a contract to the contrary. Again and again, we have to stress this. Suppose there is an understanding that on specific goods mentioned in the contract, he has no right of general lien or even a specific lien, then those goods cannot be retained. But that's again contract. If nothing is mentioned, bailee has a specific lien for the services rendered on those goods. Bankers, factors, wharfingers, attorneys, policy brokers have a general lien on any goods for a general balance of account. Other than these guys, if general lien is not implied, it has to be contracted. There should be in the contract. If it is not mentioned in the contract, then there is no general lien. I'm having some trouble getting into the. I'll do one thing. 3-1?
8 voice.
Sorry. This is connection. Give me 1 minute. Today, something seems to be going. I'm not able to access the site, boss site. Usually, I will reach it today. So, these are general differences between general lien and particular lien. So, I think it's obvious that general lien is applicable to any goods belonging to the bailor, whereas particular lien only on those goods in respect of which service has been rendered. General lien is not automatic, except for those guys, except for those special categories, it is not automatic. But particular lien is automatic. You can automatically, Madan, just give me 1 minute. Now, we move on to rights of bailor and bailee. Means, earlier we saw rights of bailor separately, rights of bailee separately, duties of bailor and duties of bailee. Now we are seeing a common right, which is available to both the bailor and bailee against a third person. Against a third person who is not a contractor. Now, bailee has been given possession of the goods by the bailor, right? Now, if those goods are taken away from him or seized by somebody, if a third person wrongfully deprives the bailee of the use or possession of the goods bailed, okay, then both of them have the right to sue him for recovery. Right? Means normally only the owner will have the right to sue. Bailey is not the owner. But since he is a bailee, he has the same right as the owner might have had in the like case if no bailment had been made. So whatever the owner would have done, he can do. He can file a suit. When he files the suit in the court cannot ask him, who are you? Why are you filing this suit? He'll say, I am the bailee. The goods have been given to me for some purpose, for the use or possession, and I have been asked to keep. This guy is now taking it away. Therefore, I have the right to think. See, I'll give a simple example of bailee this way. See, suppose there is a bailment and movable goods are in the possession of, say, a bailee. Now, if suppose the government authority is attaching those goods, trying to attach, now they can attach, no doubt about it. Normally, if the bailor owes any tax, etc., the goods can be attached. Okay. But here there is a contract of bailment. Bailee is also sitting there. So the bailee can now file a suit for deprivation and he can ask for a stay or injunction and say, so long as I am using it, there is a contract of bailment, it cannot be done. Okay. I mean, I'm giving one example. Courts have discretion here. When the suit is filed, the courts have a discretion to decide. But see, you have a right to sue. Please understand. Filing a suit doesn't mean the order will be favorable, but the bailee has the right to sue. Normally, a non-owner cannot sue. Here, because he is the bailee, he has the same rights as the owner has. Okay. In case any compensation is received on the suit for damages or anything, then the bailor and bailee have to share it proportionately according to their respective interests. See, simple. Suppose the bailee has spent some money, that money will be given to the bailee. Other than that, if there is any compensation, they have to share it in proportion, is the point. Right. Now, finally, we come to the termination. Suppose there is a period of bailment. If the period comes to an end, bailment over. Obviously, if there is a purpose for the bailment, if the purpose is completed, bailment over. Okay. Now, the bailee acts in a manner which is inconsistent with the terms of the bailment. See, we gave a classic example. When he is misusing the goods or something, I have the right to come and take it back. Bailment, contract of bailment is. For that, you have to give notice. Ideally, you have to give a notice in writing or orally, no problem. But you have to tell him, you are misusing the goods. I will be taking possession back. You remember the rule? A gratuitous bailment can be terminated by the bailor at any time by giving a notice to the bailee. Whereas a non-gratuitous bailment cannot be terminated by the bail. Again, even a gratuitous bailment, when you are terminating it, okay, in case the bailee has done something where he will incur a cost, which is more than the benefit from the bailment, then or by using the goods, the bailor has to compensate even in gratuitous bailment. Non-gratuitous bailment cannot be terminated before the expiry of the term. Okay? Or before the fulfillment of the purpose. If that is done, there is a breach of contract. Okay, when I say cannot be done, how can I say cannot be done? Fellow may come and take the goods away, but that is contractually, it's a breach. And the bailee has the right to file a suit against the bailor for compensation, etc., etc. A gratuitous bailment terminates upon the death of either the bailor or the bailee. Normally, a contract will come to an end with the death. Okay, but see, any contract which involves specific performance will come to an end at the time of death. But normally, suppose I have borrowed money, or A has borrowed money, and he has not. The money is due. A dies. Contract does not come to an end, boss. The money has to be repaid. By who? By the estate of the deceased. Please be careful. Legal heirs and all need not pay. When Mr. A dies, A is having 1 crore debt. The son need not pay. Son is totally not. But suppose A had assets. Those assets can be used for paying the debt. Please understand this. Okay. Father's debt, son need not take. There is no legal binding. The son takes it morally, that is different. Morally, he has an obligation, he does it. Wonderful. Salutes to him. But legally, there is no obligation on the legal heir to pay debts. With that, the whole subject is over. I'm just giving this to you as a general legal principle, nothing to do with bailment. Okay. I am unable to log on to this. It is not going. I'll just inform Mr. Ram. I'm not able to log on to the query pad. Kindly check out what is the problem. Okay. If the goods are no longer in their original condition or they are destroyed, the bailment is automatically terminated. So Baylor death, Bailey death, destruction of the goods. So the whole concept of bailment is come to an end. The goods were given for a particular purpose. The goods themselves have been modified. They can no longer be used or destroyed. Okay. Now, think of examples. Think of some examples. When you're sitting calmly, think of some examples. How goods can, change their condition so as to become no longer relevant for the bailment. Like that. Simple example is when goods rust or something happens to them by which they cannot be used for the bailment, then, or if they are totally destroyed, then the bailment is automatically terminated. Now we come to a very interesting area. Macaulay, rightly or wrongly, combines it with bailment because he talks about the finder of lost goods. Now, there's a popular saying in English, I don't know how many of you accept this. Finders, keepers, losers, weepers. No, sorry, that is not the law. The finder of goods cannot retain the goods. Okay, he has to make a reasonable attempt to find the true owner. The finder of lost goods has a duty to make a reasonable attempt to find the true owner. But whatever expense he is incurring voluntarily, friends, this is also a quasi-contract. Because no offer, no acceptance. Fellow picks it up. He now makes some diligent search for the original owner. Whatever amount incurred by him, voluntarily incurred by him to preserve the goods and to find out the true owner can be, he can take it from the true owner. Now that is okay. Whatever I have done, now I'm asking for the money, he doesn't pay. Then I have a right of lien. See, so the finder of lost goods has the same right as the bailee of lien. He may retain the goods against the owner until he receives the compensation. Means the amounts incurred by him and the time taken by him for preserving the goods and to find out the true owner. Now, where the owner has offered a reward for the return of the goods lost, the finder may sue for such reward and may retain the goods until he receives it. So that is why this comes under, generally it comes under bailment, because the finder of lost goods has the same rights and duties as the bailee. In addition to that, he can recover any expense incurred by him for preserving the goods and finding out the owner. Can the finder of lost goods sell those goods? You would have studied this in Sale of Goods Act. Sale by non-owner. Okay, sale by non-owner. One of the examples of sale by non-owner is finder of lost goods. Why? Because the finder of lost goods is not a true owner. See, again, I'll tell you who else will come in this category. Many times, we go to, we travel by flight and or even by train. And, in your hurry to get out of the train or the flight, you are reading a book or your mobile phone or your whatever, you leave it in the seat and you go away. Then you reach another place. By then you feel this is not worth it. Therefore, you proceed with your life. But the airline company is now a finder of those goods, and they will usually retain it in lost and found. Chances are, if you write to them, they will send it back to you. But then sometimes the cost of couriering those goods may not be worth it. It's better not to do it, to go away like that. In fact, I lost a book like that and spiced it. I could never get it from them. Okay, even when I said I will come and take it, they didn't give it. Anyway, but the point here is, finder of lost goods has the right to sell. There's a popular serial also, where reality show where these goods which are, recovered by the airlines and all, they sell it in lots by auction, because When can they do that? If the owner of the thing, commonly the subject matter of sale, cannot be with reasonable diligence be found. The owner cannot be found. Okay. So reasonable diligence, which is why they normally wait for 2 years or 1 year. For 1 year, if nobody is coming to claim it, they will say, we have. Because how long can I store these goods? So whatever is that. If he or, the true owner is discovered and we tell him, we've got your goods, we will send it. This is the courier charges. Please pay and collect. He says, I don't want those goods. He refuses to pay the lawful charges. Then the finder may sell it when the thing is in danger of perishing or of losing the greater part of its value, or when the lawful charges of the finder in respect of the thing found amount to 2/3 of its value. 2/3 of its value. Please remember. So first reason, either the true owner cannot be found, or if he refuses to pay, then in both either of these cases, if the goods are in danger of perishing or losing the value, they can sell. Or the lawful charges, the storage charges, etc., is amounting to 2/3 of the value of those goods, then the goods can be sold. See, usually this may not be asked as a theory question. They might give it as a problem. Then you should remember the rule. Did you make a diligent search to find the owner? Did it? Not possible. Okay, you found the true owner, you asked him to pay the reasonable lawful charges, he refused. Goods are in danger of perishing, or the lawful charges is more than 2/3. It's amounting to 2/3 of its value. Then the finder of lost goods can sell. We move on to a very special category of bailment, which is called pledge or pawning. See, it's again very common. For example, there are many companies today like Manappuram, Gold Finance and all, Muthoot and all that, who actually do it as a branded business. Okay, you go to them, you have gold jewelry, or I have gold jewelry, or somebody has gold jewelry. You want money urgently, you go to them and you give it. He takes it, or only gold jewelry, anything which has some value. Okay, not emotional value, but real value. Market price should be there. There should be a value in a market. Otherwise, I can have some emotional connect with something, but it may not have an intrinsic value. So if it is valuable, then somebody may lend money against it. Movable goods. Remember, both bailment and pledge are with respect to goods. So basically, a pledge is a special category of bailment of goods as security for payment of your debt or performance of your promise. So where movable goods are the possession of movable goods is delivered, the purpose being that the goods will be security for payment of a debt or performance of a promise, there is a pledge. So basically the relationship between the pawner and the pawnee is, this is a problem with copy paste. Yeah. So the relationship between the pawner and the pawnee is that of Baylor and Bailey. Pawner, pawnee, pledger, pledgee, Baylor, Bailey. So pawner is the Baylor. Pawnee is the Bailey. Okay, pawnbroker we say sometimes. Pawnbroker and all. So this guy is a Bailey. He has the same rights and duties as a Bailey. Pledge is a special kind of bailment. Therefore, all the essentials of bailment are also needed here. The extra thing is that the goods should be delivered for security against payment or performance of the promise. Okay. There should be delivery of goods. See, even delivery of goods is common for bailment and pledge. Unless delivery is there, you can't keep the goods. Possession cannot be with you, and you cannot say I have bailed it. No. Possession should be handed over. Actual physical possession or symbolic possession should be handed over. Okay. Now you'll see, in addition to the rights as Bailey, In addition to the rights as bailee, pawnee has the right to retain the goods for payment of the debt or performance of the promise, together with interest and all necessary expenses incurred by him for the preservation, etc., etc. Okay. Usually, if you go to Manappuram or Muthoot, kindly, if at all, you or your relative is pledging, kindly read the terms and conditions. They have a separate terms and conditions. You have to sign it, and the manager will sign it. There, they very clearly mention all these things, and they will also give dates and all. For example, the due date for payment will be there. Say 1 year date, 1 year. Interest will be there. Sometimes the interest may be at the time of lending the money, they may reduce the interest and give. Sometimes the interest will be paid quarterly and all. And finally, usually pawnbrokers do not ask you to pay the interest. The whole business works like this. You go there, give the gold. You ask 1 lakh. He will calculate the interest, reduce it, and give it to you. The balance amount, you take it, do what you want. Goods are returned. So that 1 year later, you come, pay the amount, 1 lakh, take the money, take the goods and go. Take the jewelry and go. 1 year later, nothing happens. Nobody's there. Then the interest starts accumulating, right? So he will give you notice. He'll say, please come and pay. So within 30 days, if you don't do that, they will mention in the contract very clearly. Read it. And if within that, if he gives the right notices, he has the right to sell. Okay. Please note, the pawnee and the bailee are one and the same. So both of them have only specific lien. He can retain the goods only for the amount due on those goods. He cannot due for anything for which other than the debt or promise for which they are paid. Again, suppose the intention is that the goods will extend to other promises also or other debts also, you can mention it in the contract. But if there is no contract to that effect, then the goods can be retained only for the debt due. But contract in the absence of anything to the contrary shall be presumed in regard to subsequent advances made by the pawnee. Now, some of you may have a challenge in understanding 174. Let me help you to wrap your mind around it. See, I am the pawner. A is the pawnee. I am the pawnee. A is the pawner. A comes to me, gives me jewelry. I retain it. I give him 1 lakh. He runs away. Then again he comes 2 months later and says, I need some more money. Chalo, give it. Valuation of jewelry I see. Okay, it's worth about 5 lakhs, no problem. How much you want? Another 50,000. So take it, run, go. Now, for the subsequent advance made by me, in the absence of contract to the contrary, I can retain this original jewelry. Even though, he just came to me and took money, I was having his gold. It's a subsequent advance. For that, I can retain this goods. Okay, that's understanding. But suppose I have lent money to him long ago without security. Now he gives me security and says, give me 1 lakh. This security cannot be used for the old debt. Got it? But suppose I have lent money against jewelry, one shot. Again, he comes and borrows more money. Subsequent advances, I have the right to retain the same jewelry. Okay. Pawnee has the right to extraordinary expenses incurred by him for preservation of the goods pledged. Okay. But he cannot retain the goods for those expenses, for extraordinary expenses. Right. Usually, when you are giving the goods for pledge, they will keep it safe for you. But after the due date, if you don't come and collect it, they will charge charges for keeping the goods in storage, because they're going to keep it in a safety locker. Especially jewelry, they'll be keeping it in a safety locker. My father had this fantastic theory of he all his property documents, he will give it to the bank and borrow some small amount and keep it. Small amount he'll borrow. Okay. And he'll say, those guys are going to keep it safely for me. Okay. They're going to keep it safely for me. If it is with me, it might get lost. Like then he has a beautiful theory for this. Anyway. Suppose the pawner makes a default. Means he does not pay the debt. The pawner makes default in payment of the debt or promise at the stipulated time in respect of which the goods were pledged. the pawnee has two remedies. He can file a suit against the pawner upon the debtor promise and retain the goods pledged as collateral security. He has that right. He may sell the thing pledged on giving the pawner reasonable notice of the sale. Now, the section does not mention what is reasonable notice, which is why I ask you, when if at all you are pawning with a reputed branded, gold loan company like Muthoot or Manappuram, you will see that they very clearly mention the consequences. Why go there? Go to a bank. Any bank will give you jewel loan now, rural banks. Before they give it to you, they'll give you the contract. That if you read the contract, they'll say, in case the pawnee or pledgee does not pay the amount, but the pawner does not pay the amount within such and such a time or the due date, they will mention, then the bank has the right to retain the goods. The bank shall give notice of 30 days. If within the next 30 days the amount is not paid, then the bank will give a public notice for auction of the goods. Within 15 days, if the pawner comes and retains, he can take it. But if after that also he doesn't, then they can auction it and sell it. They will usually auction it. Okay, not a private sale, but public sale. So that everybody can come and bid and take the jewelry, whoever buys it. Sometimes, in these cases, the pawnee will not be very keen on driving a bargain. Why? Because so long as he gets the amount due, he is happy. Sometimes you will get a bargain in these sales. Okay. Now, there are two possibilities. The goods are sold by the pawnee. The proceeds of sale is less than the amount due. Then the pawner is liable to pay the balance. Right? That is why he has two remedies. He can file a suit also. Suppose I sell the gold and still money is due, then I can recover it by a suit. Now comes the next thing. If proceeds of sale are greater than the amount due, then pawnee has the duty to pay the surplus to the pawner. He has to give back. Okay, this is the rule. The whole thing, if some of you recover, you would have read it in Nemo dat quod non habet. Sale by a non-owner. Sale by non-owner, especially in sale of goods, right of sale for a unpaid seller. The unpaid seller has right of sale. Almost same rights are for a pawnee when the amount is not paid. Right? This you will come across this in sale by non-owner, pledge by non-owner. Okay. As the Baylor of goods, pawner has all the rights of a Baylor, and the pawner has the right to redeem the pledged goods. Okay, where the pawner makes default in payment of debt on the due date, he may redeem the goods pledged at any subsequent time before the actual sale. Do you remember what I said? The contract may be that the bank will say, if on the due date you don't pay, we'll give you 30 days notice. After giving you 30 days notice, if you don't pay, then we will put it on auction. But before making the auction, we'll give 15 days public notice. Any time before that, the pawner can come and collect he can pay the amount and take it. Okay. This is a right of the pawner. But where the redemption is after the due date, he must pay in addition any expenses which might have arisen from his default. Okay. So duties of pawnee, same as bailey. Duty to take reasonable care. Duty to not make use of pledged goods. See, special bailment, only security, you're not supposed to use. For example, I'm taking jewelry as security and lending money. Then tomorrow I want to go for some function. So I take all the jewels, wear them and go. No, not to make use. Duty to return the goods when the debt has been repaid. Duty not to mix his own goods. Same thing as a bailey. Duty not to do any act which is inconsistent with the terms of the pledge. Duty to return accretion to the goods, if any. Accretion to goods will happen only with living things. Non-living things cannot grow. Please, don't expect such miracles in this Kali Yuga. You're not going to see that happen. If you have 1 kilo of gold and you keep it safely, it will not become 1 kilo 100 grams. I don't think so. Okay, but living things can grow, etc., etc. Okay, can have children. A hen can have more chicks. All that. Cow can have a calf like that. All the examples on accretion would be some living things only. Check it out. The duties of pawnor. Same as Baylor, na? But in addition to that, the pawnor is liable to pay the debt and compensate the pawnee for extraordinary expenses. The pawnor has to disclose faults which may put pawnee under extraordinary risk, if at all. If loss occurs to the pawnee due to defect in pawnor's title, the pawnor must indemnify the pawnee. We see all this we saw in bailment. If the pawnee sells the goods due to default, he must. The pawnor, if there is any deficit, must pay the deficit. Same way, if there is any excess, the pawnee should return it back. That's also duty of the pawnee. Finally, we are seeing pledge by non-owners. Similar to nemo dat quod or non-habet. Nemo dat quod non-habet. What does it mean? I'm sure today I'm not able to see this. See your query pad. I don't know why. It's not. I'm not able to reach it at all. Usually, I will be able to reach it immediately. Anyway, so what I will do is, in case you are raising queries and I'm not answering them, don't get worried and don't get excited and don't get angry. I have a problem here, but your questions will be addressed. So whatever question comes to your mind, you put it in the query pad. Maybe if not today, next class I will. I may be having 1 or 2 more classes. I will address important questions in that, definitely. But in the meantime, listen and just concentrate on what I am saying. Nemo dat quod non habet is the general rule. Nemo dat quod non habet, roughly translated, it's a Latin phrase. It's a Latin phrase from Latin, Roman language Latin. A person cannot give something which he does not have. A person cannot give something which he does not have. I am not the owner. So how can I give better title than the owner? You understand? The general principle is nemo dat quod non habet. A non-owner has no right. I am not the owner. How can I give it better? Which means, suppose you are buying the goods from the non-owner, the person who is not the owner, the contract is void. Because he has no business selling the goods. You can't take your neighbor's goods and sell it because you have no right. You are not the owner. You cannot give a better title than what you have. And what is your title? Zilch. So you can't give a better title than what you have. Nemo dat quod non habet. A person cannot give a better title than what he has. Correct? This is the rough translation. The exact translation of the Latin would be slightly different. But a person cannot give something which he does not have. In this case, the ownership. So now we come to the exceptions of nemo dat quod non habet, which is first, a mercantile agent. Now the mercantile agent is not the owner. He is only acting on behalf of a principal. But within we will be seeing agency very shortly in today's class. Basically, an agent who is a person who acts on behalf of a principal. So when I have appointed so and so as my agent, well known that he is my agent, anything done by him is valid. A pledge by him will be valid. Because the presumption is that the agent has the right to pledge. The presumption is that the agent has the right to pledge. So even if the mercantile agent exceeds his authority, right? See, it's simple. What is being protected here? Whenever we study law, I always say, don't only mug up the content. Find out why. What are we protecting here? We are not protecting the owner or the agent. We are protecting the third party. Got it? I am a money lender. You are the agent of A. You came to me. You pledged goods. I took it. I honestly believe that you had the right and I know that you are the agent. That I know because A has already told me, so-and-so is my agent. I am bound by whatever he does. You came to me and pledged. I honestly believed it. I honestly believed. I am the pawnee. I honestly believe. Okay. So the mercantile agent should be in possession of the goods with the consent of the owner. So the goods should be in the possession of the agent in the consent of the owner. And he should act in the ordinary course of business. And the pawnee should act in good faith. I should not have knowledge that so I should not collude with the agent, where if the agent does not have the right to pledge, or if the agent has been specifically instructed not to pledge, and I'm aware of it as a pawnee, then I'm not acting in good faith. But suppose I'm not aware of it. I'm sitting in the bazaar waiting for a customer. This fellow comes, pledges, takes money. I know this guy, he is a good fellow agent. I know who is the agent of here. That's all. I have acted in good faith. So now the agent is not bound. It is the principal who will be bound. Okay. The pawnee should not have noticed that the pawner has no authority to pledge. Notice means knowledge. So there is again good faith. If I have knowledge, it's not good faith. When I act in good faith, later on, when you come to General Classes Act, we'll take up good faith in detail. But basically, good faith is where you acted innocently and without knowledge, honestly believing that what you're doing is correct. That's a good faith. Okay. In fact, the word good faith, you can also use the word bona fide. The opposite of bona fide is mala fide. So when you do something and it results in a loss to somebody, but yet you acted in good intention, bona fide. Okay, that is the whole point. We'll talk more about it when we come to General Clauses Act. Another example of pledge by non-owner, pledge by a person in possession under voidable contract shall be valid. 178A of the Contract Act. It's a very interesting thing. You would have seen, again I'm telling you, whatever you're seeing here, if you just change it, pledge by sale by non-owner, that's all. All these sections you would have seen in sale. Now we are only talking about pledge. The principle is very, very simple. Okay? Voidable contract is valid till it is resigned by the party at whose option it can be voided. Please understand, a voidable contract can become void. But till it becomes void, it is valid. Am I making sense here? Okay. Now, the pawner has obtained the goods under a voidable contract. How? Maybe fraud, misrepresentation, by which the consent of the other party has been obtained by fraud. Right? So, the pawner has obtained the goods by exercising fraud. He is having possession of the goods. The other party has not resigned the contract. It is a voidable contract, but the other party has not resigned the contract. That's why it's called voidable contract. It is a valid contract till such time it is induced, it is resigned or rejected by the person whose consent was induced by fraud. No, that fellow is not aware that his fraud has been practiced on him. In the meantime, the guy who has obtained it under fraud, under voidable contract, is in possession. He pledges it. Now the contract so induced should not have been resigned. Now the pawnee again takes the goods in good faith. This good faith is very, very difficult. See, many times I am sorry to say this, friends. I'm taking you into the murky depths of criminal law or criminal behavior. There are a lot of pawnbrokers who are also known as fences. F-E-N-C-E-S. Fences. Fencing is also fighting with the sword. No. And fence is the boundary between your land and your neighbor's land. You put something to prevent him from entering. It's called a fence. But see how English language has so many meanings for the same word. Huh? Here he is called a fence because he takes the goods, knowing that it is stolen goods are obtained by fraud. Then it is not a good faith. There are well-known fences. The police know these pawnbrokers. Whenever the goods are stolen, first place they will go is to the pawnbroker's shop and they will ask him, so-and-so reported goods have been stolen. Have they come to you? No, sir, it has never, I'm not aware, but then they will search and they'll find that fellow has taken and given money. Okay? So that should not be the case. The pawnee should take the goods in good faith, without knowledge. That is okay. And the pawnee should not have notice of the pawner's defect in title. That is that's what I said. When I am a fence, my job is to collect stolen goods and give money or take pledge of stolen goods. Then I have knowledge here. But if knowledge is not there and in good faith I have done. Now, friends, tell me one thing. Who are we protecting here? Of course, taking goods under by inducing consent through fraud is wrong. But so long as the contract is not avoided, it is valid. During the validity period of that contract, an innocent third party, the pawnee in this case, the innocent third party has given money in good faith. That fellow is protected. So the pledge is valid. If at all the guy the owner of the goods wants to get money back or whatever, he has to file a suit against the person, the pawner, the person who obtained the goods under a voidable contract. He should recover the money from that fellow and then maybe come and take it away. But till that happens, he cannot happen. Okay, it's a very complicated thing. But basically, the pawnee, at best what the pawnee can do is he can tell the true owner, boss, you want the goods, no problem. I gave that fellow 1 lakh. You give it to me with interest, etc. My right as a pawnee, I'll give the goods back to you. You give me an undertaking, indemnity, that tomorrow if that guy comes and demands, you will compensate me. Because for all you know, you may not be the true owner. He may be the true owner. But you have got a court order. You got so many things. You are saying that you are the true owner. I believe you. But give me an indemnity bond, take the goods. Why indemnity? Because tomorrow, if the original pawner comes back and says, I am the true owner and he proves it, then the pawnee is in difficulty. He would have returned the goods to the wrong person, non-owner. Therefore, indemnity should also be taken. I'm giving you the legal, the law as it is. Okay. One second. This internet connection irukilla. Internet irukilla connection. Ana avanga site போக மாட்டேங்குது. ஆமா சார் சைட் தான் சார். எனக்கு இதுலயே ட்ரை பண்ணி பார்த்தேன் சார். Okay. Srushti acquired valuable diamond at a very low price by a voidable contract. So voidable contract means any contract induced where the consent is obtained, where the consent is not free, where the consent of the other party is not free. Free consent is not there, voidable. Coercion, undue influence, fraud, misrepresentation. Okay, be careful. Bilateral mistake, void, not voidable. When there is a bilateral mistake, void, not voidable. Okay. When both the parties are under a mistake, then as to the subject matter of the thing which is the substance of the agreement, then the contract is void, not voidable. But where consent is induced by one of these, coercion, undue influence, fraud or misrepresentation, the contract is voidable. Srushti is acquiring a valuable diamond at a very low price, okay, and now pledges it. She goes to the Mr. VK and pledges it, okay. Is this a valid pledge? Very important line, and I want to stress this line, and I want you to note it, and I want you to remember it also. If it is not mentioned in the question in the exam, you have to assume it. This is to be assumed, that the voidable contract was not resigned. If the voidable contract had been resigned by the other party, it is void. Then Srushti has no business to pledge. But so long as the voidable contract has not been. Now, you don't please ask me how do we know whether it was avoided or not. That is not my problem. That is an evidence issue. Right. One way is the owner gives a public notice. Right? The owner, because the owner may not know that this Srushti has pledged. So he will not know who is the pawnee. But he can give a public notice, which is automatically, it has been rescinded then. So the dates become very important. The date of pledge and the date of public notice become very important. Okay, in a court case. As to whether, but in this case, for this question asked in the November 2019 examination for a measly 2 marks, the answer is Srushti, since the voidable contract has not been resigned, okay, pledge made by Srushti is valid. I know this sounds, some students get angry and start saying, sir, how can somebody who does fraud, how can they be protected? They are not being protected. The innocent third party is being protected here. Please wrap your minds around that. Okay. Where the pawner has only a limited interest, where the person pledges goods in which he has only a limited interest, valid to the extent of that interest. For example, I am the pawnee I can sub-pledge, or I can go for I can take these goods to the extent of the loan given by me. I can again pledge the goods with another bigger guy. Okay, I can do that after all. But again, remember, you should get the right to do that. But suppose, as per the contract, you agree. In case I want to pledge, I can in turn pledge. You agree to it as the pawnee, then I can go. To that extent, I can create a pledge. Okay, to the extent of my loan. Pledge by co-owner, where there is a common ownership, co-owner can create a pledge. I don't think this is strictly pledged by non-owner. You can say this is pledged by co-owner, because co-owner has a right to part of the goods. So he is a owner for part owner of the goods. So he is not a non-owner, but still it is given here. Pledged by seller or buyer in possession. Okay, where the goods are unpaid, remaining unpaid. Okay, seller in whose possession the goods have been left after sale, or a buyer who with the consent of the seller obtains possession of the goods before sale can make a valid pledge. But then again, remember, the pawnee should act in good faith and have no knowledge of the defect. Okay, a seller who has not paid the money. Okay, and a buyer who is obtaining the goods before the sale can make a valid pledge, provided the pawnee acts. The bottom line in bailment and pledge is possession, possession, possession. If a man has possession of goods, it is presumed that, or if a person has possession of goods, it is presumed that they are having it in, they have a proper title or right to hold the goods. The possession to the goods was likely, unless the contrary is proved. Right? So, distinction between bailment and pledge, my suggestion, you go through it. It's there in the Institute material also. By now, I think you would have got the basic thing. One more thing, remember, while we say distinction between bailment and pledge, basically pledge is one kind of bailment. It is not as if pledge is totally alag. No, it is one kind of bailment, except that some additional points are there for a pledge, where the goods are being given as security. Okay, so bailment is a bigger set in which pledge is a subset. Right? Bailee has no right to sell the goods. Okay, he has only right to retain, whereas pawnee has the right to sell. The pawner fails to redeem the goods. Right. So this is bailment and pledge, right? We have come to some sort of a end of bailment and pledge. Now, at this point in time, the time now is something like 8 o'clock, nearing 8 o'clock. I'm going to take a small break here for a particular purpose. I'm going to take a small break here. Let us see. Then I'm going to, I need to connect with that query pad. That's a big problem. I'll check out what the problem is. I'm giving a small break for 5 minutes. After the break, we will take up agency. Okay, agency. Ram, Mr. Ram. Yeah, there is an issue. Can we have a break for 5 minutes? Okay. So welcome back from that break, which I thought I will give now. Some technical glitch, obviously from my side, unable to access QueryPad, which means I'm missing out a lot on the interaction from all you people. Don't worry, whatever queries are raised by you, I will answer it by whenever next time we meet. Important queries will be answered. Suppose anything, if you're sending a message and you're expecting an answer, maybe this time it's not going to happen. But I will give you an answer later. So, Indian Contract Act 1872, we saw 3 types of contracts, right? Or rather, we've completed 4 types of contracts: indemnity, guarantee, bailment, pledge. Now there's a 5th one, 5th contract. That is your agency. Contract of agency. This is another special type of contract that Macaulay thought he should make special provisions. Please understand, all these 5 special contracts operate within the framework of the Contract Act. So all the essential ingredients of a contract should be there for these contracts also. What are they? You should have consensus ad item, you should have capacity, etc., etc. But agency is a very special category. We will see. One ingredient of a normal contract need not be there in an agency. We'll see that what it is. We'll see what that is. So, overview of this topic. First, you should understand what is agency. Then, how an agent is appointed. Then, what are the express and implied authorities of an agent? More than express, implied authority. We saw one example. And a mercantile agent having possession of the goods in the absence of, any contrary order can pledge. So the agent has a lot of authority to do things, right? Then we can talk about sub-agents. And while you are talking about sub-agents, we should talk about substituted agents also. Sub-agent, substituted agent. Then ratification means approval of an act which is done without permission. Subsequently, the act is done without permission, but subsequently I agree to it. It is called ratification. Revocation of the agent's authority, duties, obligations, and rights of an agent. A relationship between third persons and the agent and the principal. Okay. Agency is not defined in the Contract Act, but the word agent is defined as a person who is employed to do any act for another or to represent another in dealings with third persons. Agent is a person who is employed to do any act for another or to represent another in dealings with third persons. Simple example. I'm representing a client before the income tax authorities. I take a power of attorney from him. Now I am an agent. I represent that person in his dealings with the income tax department. There's a very formal power of attorney which is on a stamp paper. We get that signed in my favor. The client signs it. Then onwards, whatever statement I make is binding on the client. So the client is definitely aware of it. Why is he giving me the power? Because if this as goes there, he will make all nonsense statements. Whereas I know what to tell, what not to tell, how to represent. So he comes to me and says, Saab, you please go. Then I will say, please sign this attorney. Then only I can go and talk. Once the power of attorney is given to me, I go there. Same thing for an advocate, it is called wakalat. For an advocate, it's called wakalat. That's why it's called wakil. So on behalf of the litigant, the wakil goes and talks. Same thing here. When you represent, I give a simple example from our own profession. Another example. You are the CFO of a large multinational company. Now, on behalf of that company, you can do many things as an employee. Sometimes they might give you a power of attorney to do things which specifically they might authorize you, or even forget power of attorney. The board of directors at the meeting will pass a resolution saying the CFO shall have the following powers, 1, 2, 3. including representing us, going there. So then whatever statement made by you is binding on the company, not the board. Company. Who is your, when you are an employee of a company, who is your employer? Not the board of directors, not the MD. You are being employed by an artificial person. That artificial person is your employer. Okay. Also, anything done by you is binding on that artificial person, provided you are acting within the scope of your authority. So agency is there. In addition to that, we have mercantile agents who represent the principals, sell goods on their behalf, etc., etc. The person for whom the act is done or is so represented is called principal. Okay. So agency works on a principle. I've given the rule of agency in the bottom. Key facet per alium, facet per se. Key facet per alium, facet per se. One who acts through another does it himself. The Latin broad translation is one who does something through another does it himself. He who acts through an agent is himself acting. Alium is another. One who does something through another. Per alium, facet per se. He does it by himself. This is the Latin principle on which agency, which means the principles that we are now discussing are extremely old. They are not even invented by the British. They are there right from Roman law. The Romans had agency concepts. They had a very vibrant mercantile economy. They were traders. Except that the Industrial Revolution had not happened, the commercial part of their system or their society was quite complex. So almost all the principles of contract that we are now aware of were very much there in Roman period. Okay, most of the law that Macaulay has converted into the Indian Contract Act was taken from Roman law. Okay, and simply made a little more relevant for the time of Macaulay. That's all. Now, question you have to ask: whether the person has the capacity to bind the principal and make him answerable to the third party. Whether he can establish privity of contract between the principal and third parties. Privity of contract means whether the agent can bind the principal with respect to third parties. See, simple. Suppose I do something on your behalf without your permission, I cannot bind the third party. Right? The third party sues you, you will simply say you have no privity of contract. Why are you coming to me? Why are you? Who am I? I have no privity of contract in this. He borrowed money from you. He told you he's my agent. Did you check with me? No. Then you lent money to him. Take it from him. I am not responsible. But if I have told him very clearly, in case that fellow needs money, lend him. He is my agent. Then it's a contract of agency. The principal is bound. There is a privity of contract between the principal and third parties. Okay. So if the answer to these questions is affirmative or yes, then there is a relationship of agency. Friends, as a person of prudence who is studying Contract Act and in order to become a chartered accountant, how would I look at this? Next time when somebody comes and tells you that he is an agent, I'm acting on behalf of, the minute on behalf of word comes in, representing on behalf of, then ask him to give you proof. There should be an authorization letter. There should be a power of attorney, general power of attorney. Show me a document signed by the principal. Proof. Or if he is not having any such document, send a mail to the principal asking him, is this fellow your agent or this company your agent? Confirm it. If it is confirmed, then there is a principal agency, etc. But if you feel that he is acting on his own behalf without the knowledge or consent of the named principal, better be careful. Because any dealing with that person, the principal will not be bound. There will be no privity of contract between the third party, that is you, and the principal. So whenever somebody says, I'm an agent, check before you accept. This is a general principle that you are learning. And here you have to be very, very careful. Because somebody will come and say, I'm acting on behalf of a big shot. Now, how do you know? Show me the proof here. For example, a cinema actor will have a manager. Cinema actors have managers. Most cine actors have managers. These managers are agents, basically agents. They deal on behalf of the cine actor because the cine actor is so popular, he can't come and talk to you and me. Ordinary people like you and me, they cannot talk. So because they are so big. So they have agents like managers. But then if somebody comes to me and says, I am the manager or agent for so-and-so actor, I will say, chalo, no problem. You are a great person. But show me a kagas, show me paper where there is that fellow has signed, that so-called cine actor has signed that you are his manager, appointment letter show. Or send a confirmation from him, or here is the document, ask him to sign it and give it to me. Then I will accept that you are acting on his behalf. This sounds very boring. It sounds very thing. After all, such a great cine actor is going to deal with you and his agent has come, manager has come. Isn't it a great opportunity? Yes, it is, provided I have got a proof. Okay. Now, who can be an agent or who can employ an agent? Any person who is of the age of majority, according to the law to which he is subject, and who is of sound mind, may employ an agent. So you should be a major and of sound mind. So minor and person of unsound mind cannot appoint an agent. So minor cannot be a principal. Who can be an agent? As between principal and third persons, any person may become an agent, but no person who is not the age of majority and of sound mind can become an agent so as to be responsible to his principal according to the provisions in that behalf. What do I understand? Any person can become an agent. Even a minor can become an agent, unsound mind can become an agent. And the principal can be bound by his acts. But the principal cannot sue the agent. Third party anyway cannot sue the agent because agent is not, the principal only is liable for what the agent does. No problem. Now the principal has certain rights against the agent. If that agent is a minor or a person of unsound mind, you know very well, minor's contract is void ab initio. Right? Person of unsound mind, void ab initio. So, if we are going to appoint a minor as our agent and he does something, it is binding on me. But if he is negligent and does something wrong, I cannot sue the agent. Why? Because he is a minor, person of unsound mind, no capacity. As between the principal and agent, there is no suit, he cannot file a suit. But as between third parties, when the minor is an agent, the minor can bind the principal. Okay. So, to become a principal, there should be an element of consent and element of free will. Therefore, person should be of age of majority. According to the law to which he is subject. In India, the age of majority is 18 years. When Macaulay wrote the law in England, the age of majority in England at that time was 21 years. The age of majority at that time was 21 years. I think still it is 21. I don't know. But at that time it was 21 years. Whereas in India, the age of majority is 18 years. Okay. That is why he says according to the law to which he is subject. Right. So, the agent is a mere connecting link between the principal and third party. So, legal competence is not issue here. For binding the principal and the third party, agent, there is no, because agent is not becoming a party to the contract. Okay. But as far as the contract of agency itself, the contractual capacity of the agent becomes important. So if that person is incapable of contracting, then the principal cannot hold the agent liable in case of his misconduct. Okay. Or where he has been negligent in performance of his duties. So appointing a minor as an agent is a risk that you have to take. If you think it is worth it, do it. But if you think it's not, better not. Okay. But if you appoint a minor as an agent, the agency is valid. The agent can bind the principal. Okay. This is the answer. Very important. My guru always used to stress the point. That's why I put it in bold caps. Normally, one of the important ingredients of a contract is consideration. We saw section 25 of the Contract Act. I spoke about it, right? Voluntary promise to pay a time-barred debt. Now, when you studied Contract Act in those days for your whatever college or foundation or whatever it was, they would have given you a list of items, contracts which do not require consideration. 2 examples they would have given will come from this area. One, they will say contract of bailment, no need for consideration. Absolutely correct. Because gratuitous bailment, gratuitous bailment, what is the consideration? No need. So, contract of bailment, no need for consideration. Similarly, no consideration is necessary to create an agency. You appoint me as your agent, no consideration. Simply say, you be my agent. What is the consideration? Nothing. But subsequently, there may be some consideration. I may take commission or I may fees, etc. But for making me your agent, no need for consideration. Simply take a paper and write, I hereby authorize Sri S. Srikanth to act on my behalf or to represent me. I hereby, and that wording is very important. I hereby confirm that any acts done by him or any statements made by him on my behalf shall be binding on me. Sign. That's all. Fold the paper, give it to me, and I will see to it that I ruin your life. Because I will just go out there and do whatever I want on your behalf. Okay? You are bound. So what is the message I'm giving you? Not that I'm going to ruin your life. I'm saying somebody may ruin your life. Do not make a person an agent unless you are 100% sure of him. Similarly, do not sign a guarantee. These are, I'm giving you commandments. Okay? For life. Commandment. Don't become a guarantor. Don't make a person your agent unless you have 100% confidence on him. Okay? Be careful. These are all prudence. As a chartered accountant, one of the important qualities you have to inculcate in yourself is prudence. And what I'm now telling is prudence. You won't find it in the CA. If you ask me, sir, which part of the study material it is there, sir, I can't tell you. It is not in the study material. That is why you have 3 years articleship, where we teach you practical. This is part of the practical knowledge that a chartered accountant has to acquire through experience. So this 3 years, people like me, Buddha ho gaya, we try to come and give you the experience quickly so that you won't make the same mistakes again. But if you decide to make the same mistakes again, all the best. Okay? Good. The acceptance of the office of an agent is regarded as sufficient consideration. You sign that letter, I sign, that's all. I don't even have to sign. I can simply take the paper and go. But sometimes what happens, the other party may insist that my signature should be verified by you. So I will sign, then you will say signature verified and I sign again. So that on your behalf, when I sign, they will verify whether this signature is there. That's all. Okay. Simple. Creation of agency is simple. No need for any consideration, etc. I'm just skipping it. This is just a definition given by a Supreme Court advocate. Read it if you want. Now, we come to modes of creation of agency. Express appointment. I gave you a classic example of express appointment. Word spoken and written. You take a piece of paper, address to the whole world also, to whomsoever it may concern, or to a specific person to whom I'm going to represent. And you say, I hereby appoint Mr. Donkey or Srikanth as my true and lawful agent to act on my behalf. Anything done or any statement made by the said so-and-so will be binding upon me. Signed, sealed and delivered on this so-and-so day of so-and-so July 2022. Sign. Then I will sign. Then signature verified, you sign again. Express agency. I'll fold the paper, put it in my pocket, go, and that's it. I can do whatever I want and it will bind you. Yeah, of course, I should do it in good faith. Okay, in good faith and in your interest. Okay, that is that underlying. Suppose I do something that will prejudice your interest, later on we will see my powers as an agent. But in your interest, if I may do something, see, many times somebody may do something in your interest, but it may not be good for you. They think they are doing in your interest, but it may not be good for you. So you are bound. You cannot say, I never expected you to do all these things. Sorry, I am your agent, I did it, you are bound. That's all. Okay. In an arranged marriage, parents become agent for the boy. And they bind for a lifetime. Okay, so be careful. Are you going to make your father or mother your agent in these activities? Be careful. Okay, take your own decisions and live your life. Even if you make the mistake, let it be your mistake. Okay. Implied appointment. I know I'm wasting your time. Many of you don't like me giving comments like this, but then that's part of the way I teach and I deliver lectures and seminars and workshops. If you take that away from me, then everything is taken away. Sorry. Okay. So that's why sometimes I'll give unnecessary comments like this. Okay. Implied appointment. Express means by word spoken or written. Implied means inferred or concluded from the conduct of the parties. From the conduct of the parties. That is called implied appointment. Where expressly by word spoken or written, nothing is told. But the way they are acting, it appears as if this fellow is that fellow's agent. See, both of them are coming to meet me. That fellow is keeping quiet. This fellow is talking. So obviously, yes, I hired him as an agent. Sometimes when this stuff thing happens in my cabin, in my office, when two article clerks come, one fellow keeps on talking. When I'm asking a question to A, B will answer. I will simply ask, is he your agent, sir? Confirm that he is your agent. Because then why should he talk when the question is asked to you, you should give a reply. Instead, he is giving a reply. That means, is he your agent? Confirm that he is your agent, because from the course of conduct, there is an implied agency here. Because he is acting on your behalf, like that. So then the other fellow says, no, sir. Then you tell, what did you do? Why did you go there? Then you give me your reply. I mean, I know this sounds very silly, but then implied appointments are there. Course of conduct. Agency by necessity, I will not explain it now. When the slide comes, I will tell you. Agency by estoppel or holding out. My dear friends, you saw it when you studied Partnership Act. In those days, when you were studying for your foundation or BCom or whatever it is that you've done, you would have studied partner by estoppel, partner by holding out. See, A and B are walking in the market, bazaar, mandi mein, and then A tells the traders and all, you know what, this man is my partner. Then all of them clap hands, and then tomorrow this fellow borrows money and runs away. The market people will ask me to pay. I have to pay because why? I'm now stopped here. I announced to everybody that he's my partner. Similarly, suppose I announce that he's my partner, fellow keeps quiet and says, no, I'm not his partner. Later, I borrow money and run away. He is bound by holding out. Am I correct? Because what happened? When I said, he is my partner, he should have told, no. There is no partnership and all. One more thing. Remember, partners have what is known as mutual agency. Do you remember that? From partnership, every partner, when he acts for the firm, he is acting as an agent for all the other partners. Mutual agency. Every partner he binds the other partner. So, as between partners, there is a principle of agency. It is called mutual agency. I don't know if you remember vaguely what you studied in Partnership Act. I'm sure people like Pooja PS and all will remember very well, right? So, partners have mutual agency. Acts done by one partner are binding on the others. So, partnership, there is an implied agency. Again, it can be estoppel. Even though his name is not mentioned in the partnership deed, I have made public announcement that he is my partner. He becomes a partner by holding out or estoppel. When he keeps quiet, he is stopped from denying later. When he states, then by holding out, he becomes a partner or agent. Whatever. Agency by ratification. At the time when the act is done, the agent did not have the right, or he was not the agent at all. Later on, I confirmed it. I said, chalo, he was not my agent when he does it, but it was in my interest. He did it. And I now ratify. I accept it. Then he becomes an agent by ratification. We already saw express implied. I am not going to waste your time on this. Wow, this is an interesting thing. Is the wife an implied agent? Very, very careful. Wife lives with her husband. There is a legal presumption that a wife has authority to pledge her husband's credit. That means what? Borrow money on behalf of her husband or buy goods on credit for necessaries. Sir, you will not know. My wife has a credit card, okay, but then she keeps on going online. Check, check, check. Suddenly, I'll get a message. Some thing, so much so swiped, so much so swiped. Now, finally, at the end of the month, on the 15th of the month, I will get a bill from the credit card company. All the swipes I have to pay. Why? Because she has the authority to pledge my credit, or because I have an implied agent. She is my implied agent. She is living with me, and for her necessary. Why? Necessary is very, very powerful word. Okay. Now, what is necessary will differ from case to case. Minor's contract can be enforced on the estate of the minor for necessaries. But what is necessary? Okay. 8,000 rupees sari is a necessary. Depends. Who are you? What are you? Okay. So, very important point. Wife lives with her husband, then there's a legal presumption that wife has authority to pledge her husband's credit for necessaries. So, when can this be rebutted? Where the goods purchased on credit are not necessaries. Diamond chain. Hey, it's not a necessary. Where money has been given. Before coming out on the store, I am giving some money to her friend, 10,000 rupees, 15,000 rupees. Keep it. Any necessaries, please use it. But the wife is forbidden from purchasing anything on credit or contracting debts. Okay, expressly don't, please. Okay, of course, the best thing is to take the card back, which I cannot do. Okay, where the trader has been expressly warned not to give credit to his wife. Okay, so this fellow goes to the shop and says, jewelry shop, and says, if my wife comes and buys jewelry, she is doing it in her own name. I have no responsibility for it. Then also, if the trader gives the goods, then sorry, even if it's necessary. Now, if the wife lives apart for no fault on her part, fellow is abusing her, hitting her, and she has no other go, her father comes and takes her away, then, since he has the duty to protect his wife, since he has the duty to maintain his wife in a reasonable comfort, she has the right to bind her husband for necessaries. Again and again, please note the spelling of this word. It is not necessity. It is necessaries. So what is a necessary will differ from person to person, income group to income group, social status, so many things. Okay, that is how it is. Macaulay was very clear. He never defined the necessaries. Okay, what is a necessary will differ from. So in fact, there is a case law itself which says, for the son of a duke, 3 satin waistcoats are a necessary. Satin waistcoat is a necessary for the son of a duke. For the son of a peasant, a ordinary woolen coat is a necessary. Sorry, this sounds very, very, bad, but that is the law. So what is a necessary will differ from case to case. The same principle for wife will apply to dependent children and parents also. Children and parents, dependent. Okay. Old father, mother, they have their right. See, of course, see, one thing I'll tell you, my dear friends. You have a duty to your parents because they took care of you. Okay? You are repaying a debt. You are repaying the debt. You are not doing something great for your father and mother when you take care of them when they are aged. It is not something great. Don't be proud of it. You are only repaying the debt already paid. To your children, you have a duty to take care. You are only giving them a loan which they will pay later to their children. You are only passing on to your grandchildren through the children. Okay? So both these cases, there is nothing great you are doing. Ultimately, sirf karma hai. You have to take care of these people. Wife also karma. You just finish off the karma, you are free. Think like that. Okay? Everything will become simple in your life. Everything you are doing is karma. Just do it. And without any, feeling bad or feeling happy, dvanto moha nirmuktaha, then automatically you will be free. Okay, here's a question in the exam. Aarti is the wife of Naresh. She purchased some shares from Rainbow Silks Jaipur, and Rainbow Silks Jaipur demanded the amount from Naresh. Whether Naresh is bound. They filed a suit. Wow. Whether Rainbow Silks will succeed. They will, But in the exam, if they have asked you a question for 4 marks, you can't simply write one line. Yes, wife is an agent of husband. Therefore, rainbow silks will succeed. For that, you'll get 1 mark. So what you need to write is this entire thing. If wife lives, there's a legal presumption that wife has. So finally, you should also write, it should be presumed that the sarees purchased by Mrs. Naresh are necessaries for her. If they are necessaries, then Mr. Naresh is bound. Got it? Now we are going to talk about agent's authority. Okay. Sometimes it is understood from the nature of the act or business he is appointed to do. For example, as a chartered accountant, when I represent a client, there's a clear cut what I can say and what I cannot say. Right? But one thing, again, as a prudence, I'm telling you, when the department is asking you to accept, addition or tax, etc., you do have the right to bind. If you accept it, the client is bound. Still, as a matter of prudence, what I do, I tell the officer, sir, you have made the point. I am convinced that it's better to pay the tax. I will accept it, but I will not sign the paper now. Let me go back to my client and confirm with him and then come back. So I go back, send a mail, the client confirms that it's okay. Then I come back and I confirm it. Till then, I won't do it. I have no need to do it. I can simply accept and go. Because I am the agent, I can bind him, but I won't do it. Because tomorrow a fellow will turn back and say, nah, you should have asked me. I have asked you now. Then he will say, Srikanji, whatever you say, let's do it. Finish the matter. Sir, you are clear? Put it in writing. I will send a mail, you confirm it. Please go ahead. Then and only then I'll go. Okay. This is called prudence. Okay. If whatever, you may be the authority on law, you may be authority on accounting standard, authority on income tax. But if you do not have prudence in your dealings with the third parties and the world, friends, something of a chartered accountant is missing. Okay, because one of the hallmarks of chartered accountant is ethical behavior, prudence. We are known for it. That is why society respects us, not for only our knowledge. Don't think again and again getting all India rank in the exam is not a great thing. Unless the man or lady also has other qualities of a chartered accountant, like ethical behavior, prudence, conservatism, right? These are all hallmarks of our profession. Okay, things which are incidental to the business or are usually done in the course of such business, agreed. Usage of trade or business. Okay, see, pledge by mercantile owner is a classic example. Suppose normally in that trade, goods are pledged by the agent, then the agent has an implied authority to pledge. And if the pawnbroker has given money in good faith, because normally in the trade it's happening, everybody does it. So also came and gave. Now you say, I have no act. If you had no authority, you should have told me in ahead. You should have made a public notice that this fellow is not entitled to pledge goods. If you have done nothing, you are bound, implied. Right? Whatever may be the nature of or extent of agent's authority, it will always include the authority to do every lawful thing necessary for the purpose of carrying out. Every lawful thing justified by various customs of trade. You want the agent to do something, in addition to that, whatever has to be done, he is entitled to do. Okay. Now, agency by estoppel. This will happen only when the agent acts beyond his capacity. See, simple. The principal by his conduct or his word has induced the third persons to believe that what was done by the agent is within his authority. Now, the agent then does something without authority. Even then, the principal is bound to the third persons. Okay. Almost all problems on agency will be on this one single point, whether the principal is bound to a third party. Invariably, the question will revolve around that. As between principal and agent, okay. As between principal and third party, whether the principal is liable, whether the third party can sue and succeed. Okay. Never say, can I file a suit? You can always file a suit. You should really ask, can I file a suit and succeed? Okay. So, in estoppel, the principal is bound by the acts done by an agent, even though he has exceeded his authority, provided the following essentials are there. Even though the agent has exceeded his authority, the act is binding on the principal by the principle of estoppel, provided these essentials are fulfilled. 1. The principal must have made a representation. The representation may be express or implied. Right? The representation may be express. Express means word spoken or written. Implied means course of conduct. The representation must state that the agent has an authority to do certain act, although really he has no authority. I'll give a simple example of implied representation. See, the agent comes and pledges the goods. Moneylender lends the money. He meets the principal in the marketplace. He says, hey, you know that fellow, your agent, he pledged the goods. Is that okay? He says, yeah, okay, chalo go. So, by your action, what you have shown, that fellow normally has the right to pledge the goods. Subsequently, you instruct that bugger, the agent, not to pledge. Between you and him, there is a clear-cut understanding not to pledge. But that rascal comes and pledges the goods. Now, you go to later on the moneylender says, Baba, that fellow pledged the goods, you pay the money. Hey, why should you? I told him not to pledge. Sorry, that is between him and you. As far as I am concerned, when I asked you what you said, can he pledge the goods? He said he can pledge. So normally I am assuming that he has the authority. So you made a representation impliedly that the agent has an authority to do an act. But now you are saying he has no authority. That's not my problem. And at that time when he pledged, you took the money now and you repaid. Now you this time also you have done it. I have given the money, you are bound. The third person must have believed the representation, and of course the word is missing here, but you include it. He should have acted in good faith. So with knowledge, suppose the agent comes and tells him, I have no right to pledge these goods, but that fellow Srikant, my principal, is a rascal, he owes me money. I am going to take this money and run away. Knowingly, if this fellow gives the money, then it's different. But suppose I come to him, the agent goes to him innocently and says, I want some money, goods are there belonging to Srikant. Can I pledge? Yeah, go ahead. And then money is given. Sorry. The third person believed the representation, made the contract on the belief of such representation. So agency by estoppel is again partner by estoppel. Yeah, same. A partner by estoppel can bind the other partners. Okay. Which is why I am telling be careful, be careful, be careful. If you want to do something, do it properly. Inform people clearly what you are expressing. Okay. An agency of necessity arises due to some emergency circumstances. In an emergency, a person is authorized to do what he cannot do in ordinary circumstances. So, for agency by necessity, the first thing that you should prove is there is an emergency. So, the agent is authorized to do a certain act. When there is an emergency, he acquires an extraordinary or special authority and he can do certain things to prevent his principal from loss. Classic example given by Macaulay in the Act. Let me see if it's there. It's not there. We'll see the difference, then you'll understand. Normally, in a normal circumstances, 188, agent has an authority to do an act, which he has the authority to do every lawful thing necessary to do that act. Necessary. Only those things that you show are necessary you can do. But suppose in an emergency, he can do all such things for protecting his principal from the loss as would be done by a person of ordinary prudence in his own case under similar circumstances. See, sometimes when somebody does something bad to you, the first question you will ask, emotionally is, if I had been in your position, will you do it to me? If like that, will you agree? That is the real test. Will you, if it is you, will you allow it? Okay. Then what is good for you is good for others. So if it is not good for you, how it will be good for him? For your own goods you won't do, for him you will do. No. So that's a clear common sense test. Would a man of ordinary prudence do this in his own case under similar circumstances? No. Then what you did is wrong. But suppose, yes, that's what they will do normally, then okay. Man of ordinary prudence, not defined. Okay? Not defined. What is ordinary prudence? In fact, the word prudence itself has been used here. Do you see that? The word prudence has been used here. It's a very powerful word prudence. It's important. Temperance, fortitude, prudence, and justice. These are the 4 qualities. Temperance means control on what you're doing, controlled, not excess. Fortitude is the ability to bear adversities. Justice, of course, is equal. And prudence, okay, being careful in what you're doing. Common sense, applying common sense in what you're doing. Okay, so this is a frequently tested question in the exam. Agency, emergency, that is agency by necessity, frequently asked in the exam. Invariably, they give the same type of example. Just like for acquisition of goods, only living beings can be taken. Here, only examples of transportation can be taken. When the goods are in transit, only all this emergency will happen. Point is, agent should not be in a position or have any opportunity to communicate with this principal within the time available. That is why I am saying most of the cases in agency by necessity will be in transport. Because when the goods are being transported and they are in a remote location, the agent may not have the ability to talk to the principal. See, today that is bullshit, because today wherever you are in the world, you can WhatsApp, you can call. But assuming that some extraordinary circumstance, he is not able to communicate. So first thing that the agent should establish is, I was not able to communicate with you. Or maybe the principal is in a place where he cannot be contacted, out of range. All sorts of connectivity problems all of us are facing. In addition to our other problems, today we have connectivity problem also. Okay. We thought the internet will solve problems, but the internet has given us some solutions and more problems. There should have been actual and definite commercial necessity. Please note, necessity. That is why this is called agency by necessity. Okay. The agent should have acted bona fide, in good faith, and for the benefit of the principal, in his interest. See, benefit need not always be profit. It can be reduction in loss also. I repeat, benefit need not always be profit. It can be reduction in loss also. Suppose the principal would have incurred a loss, the agent can protect him from a higher loss by incurring a lesser loss. Got it? The agent should have adopted the most reasonable and practicable course under the circumstances. The agent must have been in possession of the goods belonging to his principal and which are the subject of contract. So obviously, if possession is not there, you have no business to do it. The goods should be in his possession. Okay. And the agent should have adopted the most reasonable and practicable. He should have acted as a man of ordinary prudence would act in his own case under similar circumstances. See, Macaulay gives such beautiful tests. Okay. If properly applied, nobody can. Bullshit is not going to work here. Will you have done it for your own, in your own circumstances? No. Then how you can do it for me? That's all. Now, as I told you, agency by necessity, invariably transport will be there. Believe me. Because Rahul, a transporter, was entrusted with the duty of transporting tomatoes, again perishable goods, from a rural farm to a city by Ashwin. Due to heavy rains, Rahul was stranded for more than 2 days. Rahul sold the tomatoes below the market rate in the nearby market. Why? Because if I do not sell, the tomatoes will become rotten. Then what will you get? Nothing. Whereas by selling it below the market rate, I at least got you something. Maybe even I would have got your cost back, if not a profit. Okay. Because tomato is perishable. Now can Ashwin recover the loss from Rahul on the ground that Rahul had acted beyond his authority? Means what is Ashwin's loss? Normally, if Ashwin had sold the tomato normally where he wanted to sell in the city, the margin would have been huge. Then by the time the tomato, believe me when I say this, by the time the tomato comes to the, your departmental store where you go and stylishly pick up the tomato and put it in your thing, the margin would have gone up by 10%, 10 times. The poor farmer gets nothing, whereas the middlemen get everything, whatever it is. Ashwin would have got a huge market margin there, but Rahul sold it in the rural markets below the market price. Now, can Ashwin recover? I know if it had been if I had had the query pad, I would by now Hitesh Jain or Pooja and all would have given the answer, and they would have said, no, he cannot. Why? Because the act done by the agent, Mr. Rahul, is binding on Ashwin. Why? It satisfies all the conditions of agency by necessity. The agent Rahul was in a place where he was stranded. He could not communicate with Ashwin, assuming that both of them do not have mobile phone and all. That is one problem here. Assume he was stranded, means he couldn't communicate. Okay, there should have been an actual and definite commercial necessity. Absolutely, the goods are perishable. Therefore, in order to save some money, he did it as a commercial necessity. That agent acted in good faith and to protect Ashwin. Okay, and he adopted the most reasonable and practicable course. He sold at the best price possible, so happened below the market price. And he was in possession of the goods. So check, all 5 points answered. So in the exam, what you should do, you should write these 5 points, apply the law and say, as the above conditions apply in the given case, sale by Rahul of the tomatoes below the market price constitutes an act done by an agent by necessity. Therefore, Ashwin is bound by the act done by Rahul. You should mention that Mr. Ashwin is bound by the act done by Rahul, and therefore he cannot recover the loss on the ground that Rahul had acted beyond his authority. So, agency by necessity is a special case where the agent may act beyond his authority, provided he satisfies these conditions. Okay. So, important thing is emergency. Is it there? Yes, due to heavy rains. So, emergency is there. Now we come to ratification. The word ratification means approving a previous act or transaction. At the time when the act is done, the person doing it did not have the authority. At the time when the act was done, the person doing it did not have authority. Subsequently, the principal authorizes, accepts, approves the previous act. This is called ratification. So the acts are done by one person on behalf of another without his knowledge or authority. Means the person on whose behalf we are doing it. Later he may elect to ratify or to disown. Ratify means he accepts it, approves it. Disown means he disapproves it. He doesn't accept it. If he ratifies them, the same effects will follow as if they had been performed by his authority. So once it is ratified, it is a valid transaction. But if he disowns it, then the agent is bound. Again, they will ask you a question where Mr. A sold certain goods belonging to B. See, A is a trader. B is another trader. B comes to this city. He has got certain goods with him, valuable goods. He gives it to A and says, Mr. A, keep it safely. I will come later and I will sell it myself. I will come later and I will sell it myself. He has no right to sell. He only he's like a Bailey, right? He's a Bailey. Now, what happens? Suddenly the price of the goods goes up by a sudden spike in the market. That opportunity may not come again. So whatever this fellow does, he sells the goods on behalf of that guy. And he realizes a good fat profit and he keeps it safely. Next time when this guy comes to the town, he says, you know what? The price suddenly shot up, yeah. How much? So much. Oh, so much. Oh, you sold it now? Yeah, I sold it. Is that okay? Yes, it's absolutely okay. That's all. At the time when the goods were sold, the seller did not have the right authority. Subsequent ratification makes it valid. Okay, this is as between the principal and agent. As far as third parties are concerned, you have to be very careful. You link it with Bailey. If the Bailey of goods sells it in good faith, the other party is buying, he can still claim. But if it is subsequently ratified, then the principal becomes bound and the agent is released. Right? Anything done without authority, suppose he is the Bailey and without authority of the Baylor, he sells the goods. He is not owed any money and all. So there is no right of lien, no sale. Bailey cannot sell even for that. Bailey can only file a suit for recovery, he can retain the goods. Except Pawnee. Pawnee is a different example. Other than Pawnee, any other Bailey can only retain. Bailey has no right to sell. But he sold. Subsequently, the Baylor ratifies it. Then you have an implied agency. The Baylor becomes the principal, Bailey becomes the agent. He has done an act which is now ratified. Then the Baylor is bound by the acts of the Bailey with regard to that transaction. Ratification may be expressed or implied by the conduct of the person on whose behalf the act was done. For example, the goods are sold on credit. Subsequently, the payment comes to the Baylor. Say half payment comes or full payment comes. He accepts the payment and puts it in the bank. That's all. By implication, by the conduct you have accepted. At the time when that money came to you, you should have asked, why are you sending money? I never sold the goods. He doesn't have the authority to sell like that. Right? Since you kept quiet, by implication. Or expressly, you can say, I hereby ratify. See, Macaulay was drafting this law for people in practical situations. This is not for scholars like you to sit in your comfortable air-conditioned rooms and discuss. This is for traders like me, right there in the mandi. We have to do our business. Yeah, we have to take our decisions. Okay, and when we take certain decisions, the law has to protect me. That is why Macaulay made out a framework by which people acting in good faith will be protected. Okay, that was Macaulay's concept. So, sitting in your academic ivory towers, you can have all sorts of esoteric arguments. But for a man like me, in the mandi, on the floor, I have to take a decision. At that time, I can't worry about the law. I have to do what has to be done. Then the law has to protect me. Then the law has to see the facts of the case. And that is what Macaulay did. Okay, which is why later on you'll be studying Negotiable Instruments Act. That was not drafted by Macaulay. That was drafted by another great man, Lord Mansfield, who actually went to the Arabian Sea, the Gulf, and right from Gujarat, Mumbai, of course, Gujarat, the Malabar, Kochi, and not Dubai at that time, nothing, Qatar and Oman. Okay, you had the Sultanate of Oman, Muscat, okay, all that. He went to every place and he understood what traders were doing, how they were, how credit was being given, how money was being transferred. And that framework he wrote Negotiable Instruments Act. Okay, so these great Englishmen, they really worked at it. Of course, they were rascals, they were rapacious, they were criminal fellows. But as far as the laws were concerned, they took effort to see that we got good laws, for which we have to thank them. Now, ratification may be express or implied. We saw that course of conduct or express. There should be knowledge for valid ratification. You should be aware of the facts. Okay, only a person whose knowledge of the facts of the case is materially, he is there. He can do. If it is materially, for example, if the entire story is not told, I have sold those goods. Is that okay? That's okay now. What did you sell? At what price did you sell? Then you have to ratify. You can't say, boss, I'm your good friend. You believe me now? Yeah, what? I sold the goods. Oh, is it okay now? Okay. Sorry. He was not aware of what he was ratifying. So it should be told very clearly. Boss, I sold it for 300 rupees per kg. Is that okay? Oh, 300 rupees per kg. Okay. Now he is clear. Maybe because he is thinking, will I get 300 per kg? Maybe. If am I happy with 300 per kg? Chalo, he did it. Enjoy. So he gives. But suppose without understanding what's happening, he ratifies it when his knowledge of the facts of the case is materially defective, then there is no valid ratification. The whole transaction shall be ratified. You cannot ratify that which is convenient and leave that which is not inconvenient. Okay? Principal cannot ratify a part of the transaction which is beneficial and reject the rest. For example, goods were sold in 2 lots. One lot was sold for 300, another was sold for 250. Now he cannot say, hey, I will take 300 lot, I will not take 200 lot. One. Or the goods were sold for 300, but at 90 days credit. He cannot say, I will accept the price, but credit I won't give, I will sue immediately for the price. No. Whatever the agent did, you have to ratify completely. Suppose the agent has given 90 days credit, you are bound to that 90 days credit. Without that, before that, you cannot go and ask for the payment. And remember, it's very, very important. Later on, when you join organizations and get into commercial transactions, you will understand price is not the only thing. Suppose I get a good price, but the credit terms are 90 days, the price may not be viable. Why? 90 days I have to wait now. What about the interest? That may be more than the profit I'm getting on those 300 on that price. Therefore, credit period also should be seen. Which is why cash price is always cheaper than credit. So if you want me to give you credit, I can't give the same price that I'll give to a mandi customer who's paying me cash. You want credit? Chalo, no problem. But this is the price for credit. Because I have to wait now, 90 days. Who will fund me? Okay. Remember, law and finance are closely linked. What you study in finance has a legal basis. Okay. What you're studying in law has a financial implication. Ratification of unauthorized act cannot injure third person. See, an innocent third person who has acquired title in good faith, okay, cannot be affected. When the interest of third parties is affected, the principle of ratification does not apply. For example, the goods were sold on 90 days credit. Now, the buyer has the right to pay after 90 days. That right cannot be taken away by ratification. Okay. A holds a lease from B, terminable on 3 months' notice. C, an unauthorized person, gives notice of termination to A. The notice cannot be ratified. Why? Because he has done something which is, he can be subsequently ratified. But you cannot do so as to injure a third person. Because the lease is terminable on 3 months. So B should have given 3 months notice. C is giving without 3 months notice immediate termination. B cannot ratify. Because it will injure the rights of A. He has already acquired the right to be given 3 months notice. Right? Say, similar to my credit example. The ratification should be done within reasonable time. The other party should be communicated about the ratification. The acts to be ratified must be valid. For example, an illegal act cannot be ratified. Correct? Anything which is done which is illegal or not according to law or unlawful cannot be ratified. I'll give a simple example. A is a minor. Okay. Now, minor does something, is void ab initio, right? That cannot be ratified. For example, Mr. A is my agent. A is a major. A is a major. Okay. Now A sells goods to minor on credit. A sells goods to minor on credit. Subsequently, the principal ratifies the contract. Can the recovery be made from the minor? No, sir. Because the contract is void ab initio. Therefore, it cannot be ratified. Similarly, I am the principal, he is the agent. He does something which is illegal. For example, some recovery of money is there. Before I left in the airport, I told this guy, see, that fellow has to give us 50 lakhs. Collect it somehow, Baba. Do something and get it. Hey, do something, what does it mean? It means take legal action, go to him, convince him, like that. Fellow takes 2 gundas and hits him and takes it. No, that's an illegal, criminal act. I'm not bound, nor can it be ratified by me. Suppose subsequently I say, ratify, I will ratify what you did. Sorry. Illegal acts cannot be ratified. Right? Now we come to sub-agent. There is again, as usual, there is the Latin principle, which is delegatus non potest delegare. Delegatus non potest delegare. A delegate cannot in turn further delegate. So, who is an agent? Agent himself is a delegate. In the sense, what the principal should do, the agent is doing. He himself is a delegate. He cannot in turn appoint another person to do it on his behalf. This delegatus non potest delegare. A delegate cannot in turn further delegate. So, normally, an agent cannot lawfully employ another to perform acts which he has expressly or impliedly undertaken to perform personally. Be careful. The agent can have an employee to do things on his behalf. Suppose the agent has undertaken to do something, he can employ somebody. But that somebody will not become a sub-agent. He will not become that somebody cannot go to the principal and claim anything. Nor is the principal bound by the acts done by the sub-agent. That is a very, very important point you should understand. So here in sub-agency, you have to be very, very careful. Without the knowledge of the principal, if the agent appoints a sub-agent, the principal is not bound by the acts done by the sub-agent. So a sub-agent is a person employed by and acting under the control of the original agent in the business of the agency. So acts done by the agent are binding on the principal. If the agent employs somebody to act on his behalf, then that fellow, that sub-agent, he may do certain things in good faith, valid, but those acts are not binding on the original principal. They are binding on the agent. Between sub-agent and agent, there is a contract. But between sub-agent and original principal, there is no privity of contract. This is the principle of sub-agency. So normally, agent cannot delegate. So 190 general principle, sub-agent. See, I cannot prevent the agent from appointing a sub-agent. See, he can appoint, but that sub-agent's act will not be binding on me as the principal. That is the point. So now we have to see when an agent can appoint a sub-agent. The appointment of a sub-agent would be valid if the terms of appointment originally contemplated. Suppose at the time of appointment itself, the agent says, Baba, I cannot do this myself. I will be employing some people. Suppose A has a huge tract of 100-acre land and he wants B to sell it for him as an agent. B says, I will do it. I will sell this land for you. But obviously, such a huge land, I have to get approval from CMDA or whatever, MMDA or whatever. I have to lay the roads, I have to develop it. All that needs people. So I will be employing people to do it. And those acts done by those people will be binding on you. Are you okay? Chalo. Then if it's expressly there, then the original appointment contemplated it, then no problem. So that is express. Sometimes customs of the trade may provide for appointment of sub-agent. This depends from trade to trade, geography to geography. Which is why Macaulay very clearly says, customs of trade are protected. Suppose the normal custom is sub-agents are allowed, then it is there. In these two cases, the sub-agent would be treated as the agent of the principal. In these two cases alone, the acts done by the sub-agent are binding on the original principal. Okay. Where in the course of the agent's employment, unforeseen emergency arises, which makes it necessary for him to delegate authority. Sorry, even then that sub-agent act done is not binding on the principal, but ratification is possible. It can ratify. That is always there. You can always ratify. But otherwise, unless it is expressly there or the custom of the trade may provide. If the sub-agent is properly appointed, means with the consent of the principal, then acts done by the sub-agent are binding on the original principal. Okay. But agent is responsible to the principal for the acts of the subagent. The subagent is responsible for acts to the agent, but not to the principal. If he is not, because ultimately would be an agent. As far as third parties are concerned, okay, the principal is bound. Please understand, principal, agent, subagent, third party. The subagent is properly appointed. Then he acts on behalf of the original principal. He is also an agent. He can bind the principal vis-a-vis the third party. The subagent is responsible. Now, for example, the subagent may be entitled to commission, etc. Those things are between the subagent and agent. Principal has nothing. The subagent cannot come to the principal. Similarly, if the subagent done something negligent, the loss is the agent's loss. The principal can say, boss, I don't care what he did. You have to pay me for it. But suppose the subagent does something which is fraudulent. Then the principal can file a suit against the subagent. Normally, even in the case of a properly appointed subagent, there is no privity of contract between principal and subagent. But if a subagent is properly appointed, he can bind the principal vis-a-vis third party. So the principle is, so far as regards third person represented by the subagent and is bound by and responsible for his acts as if he were an agent originally appointed by the principal, provided the subagent is properly appointed. But if the subagent is not properly appointed, then, sorry, principal is not bound. Who is bound? Agent is bound, because this will act on his behalf, right? Where an agent, without having authority to do so, has appointed a person to act as sub-agent, the agent stands towards such person in the relationship of a principal to an agent and is responsible for his acts, both to the principal and to third persons. So, improperly appointed sub-agent will not bind the principal. He will bind the agent, and the agent is now responsible to both the third party and to the principal. The principal is not represented by or responsible for the acts of the subagent. The subagent is not responsible to the principal at all. He is answerable only to the agent. If he is improperly appointed. Properly appointed, he can bind the principal with regard to third party. But the principal cannot file a suit against him unless it's a fraud or willful wrong. He can also claim from the principal, only the agent. Okay. Now, we saw sub-agent. There is something called substituted agent. Substituted agent is a person appointed by the agent to act for the principal in the business of agency with the knowledge and consent of the principal. Substituted agents are not sub-agents. They are agents of the principal directly. For example, when I am representing a case, sometimes I have to take legal support. Now, as part of my brief, I will say, on your behalf, I will hire a advocate. Now, that advocate is hired by me on behalf of my client, who is my principal, with his consent, with his knowledge. Now, that person becomes a substituted agent, not a sub-agent. Okay? That lawyer is directly responsible to my client, but I'm only appointing him on behalf of the client and instructing him as to what he is supposed to do and all. But final liability is between the substituted agent and the principal. Not a sub-agent. The lawyer is not my sub-agent. He is a substituted agent. Why I am doing it? Because that particular job I cannot do. I don't have the qualification or knowledge to do. So to that extent I am hiring. For example, valuer. Part of my job may need a valuation. I may hire a valuer on behalf of the client. I am entitled to do it. But once I appoint that valuer, he becomes responsible to the client and not to me. Okay, what acts done by him, the thing. And he can collect the fee directly from the client. Okay. But where an agent holding an express or implied authority to name another person to act for the principal in the business of agency has named another person accordingly, such person is not a sub-agent, but an agent of the principal for such part of the business is entrusted to him. So a representation is going on. Power of attorney is in my name. At one point in time, I feel it's better to hire a lawyer. I advise the client. The client says, go ahead and hire the lawyer, your choice. So I hire the lawyer. and I instruct him. I have a specific express permission from my client to hire an advocate. And I give him a brief. I tell him this is what it is, what it is. This is the case, facts of the case. Kindly argue and win the case, or kindly go and obtain the stay or whatever. Now, to that extent, he's a substitute agent. Tomorrow, if there is a fee due to him, I am not responsible. I have only named him. Now, directly the principal has to pay. Okay. In selecting such agent for his principal, an agent is bound to exercise the same amount of discretion as a man of ordinary prudence would exercise in his own case. So I have to be careful while selecting that substituted agent, whether he is competent and whether he can do the job. That's all. If I have exercised reasonable prudence, I am giving a practical example as a chartered accountant. This could be applicable in all circumstances, where the agent is given the right to, for certain specialized activities, to hire another person. That other person will become a substituted agent, not a sub-agent. And as such, he becomes the agent of the principal only. The only thing is the agent is naming him. That's all. So we already seen the whole thing. And I think by now you know what it is. Important point. Substituted agent, there's a direct privity between the principal and the substitute agent. For sub-agent, there is no privity of contract between the principal and the sub-agent, even if he is properly appointed. If he is properly appointed, the only extra dimension for proper appointment is he will bind the principal vis-a-vis third parties. But if he is improperly appointed, the principal is not even liable to third parties. Okay, that's the only point. Otherwise, there is no privity of contract between the principal and the sub-agent. The sub-agent is responsible to the agent alone, and it is not generally responsible to the principal, except where fraud is there. If there is a fraud by the sub-agent, principal can directly sue. Right? So this is the basic concept. Once you understand the basic, the rest of it is just... So sub-agents may be improperly appointed. Substituted agents can never be improperly appointed. Okay? But of course, you can do... There can be... The way I selected the agent, substituted agent, but that's between... Suppose I'm the agent and I selected the wrong guy. Then the principal feels I should not have selected this fellow. That doesn't do anything. Substituted agent's rights are there. The principal is bound. There's a direct privity there. But as my selection is wrong, then some action can be taken against me for not exercising the discretion as a man of ordinary prudence. Since the word prudence is coming so many times in this chapter, I took the liberty of trying to help you understand what is prudence. Right? Incidentally, prudence is the name of a Western. It's a Christian name of a woman. Many Americans in those days used to call themselves Prudence, Charity, etc. Okay, these are names. These are virtues. So the duties and obligations of an agent: duty to execute the mandate, duty to follow instructions or customs, duty of reasonable care and skill. I think these are obvious now. I don't want to waste your time explaining each one of them. Execute mandate means, what is mandate? Mandate is the job I am appointed to perform. Mandate. What is your mandate? Means, what have you been asked to do? That is your mandate. It's coming from the word mandatory. It's a Latin word again. Mandatory means what you are supposed to do. So, mandate. What is your mandate? What are you supposed to do? You have to do that. For example, I have to represent the party, appear on the department, and do my best to ensure that there is no damage, complete the case and bring the order. This is my mandate. Okay, I have to do that, execute that. While doing so, if any instructions are given, I have to follow it. I have to exercise reasonable care and skill. And if I am handling money on behalf of the principal, I have to maintain accounts. Okay. As a chartered accountant, I may become an agent of the client. How? Suppose the client gives me money and says, Srikanth, you pay tax on my behalf. He transfers it to my account. I have to pay on his behalf. I become an agent. So I have to maintain accounts separately and I have to show him how much money came, how much was paid, what is the balance pending, etc., etc. It is our duty to maintain separate accounts for the principal. Duty to communicate with the principal means before doing something, you have to tell him, I have to do this. I'm planning to do this, or I have done this. Within the framework itself, you told me to do, I have done this. Duty to avoid conflict of interest. Conflict of interest means what? Agent's profit versus principal's profit. Which means, suppose the principal's goods are there, the agent cannot buy it. There will be a conflict of interest, right? I cannot be the agent and buyer unless I take the consent of the principal. Where I can tell him, boss, your goods are with me. You told me to sell it, but it so happens I have a contract for supply of these goods. It is in my name. Therefore, first you have to sell it to me. Then I can only bill it to the client. Is it okay for you? Okay, what is the price? I am getting so-and-so price. Same price I'll give it for you also. But I need these goods. Can I take it? That's all. There's no conflict here. But suppose without telling him, I take it. And then I later on go and tell him, without revealing my price, I tell him, boss, I sold the goods. Yes, yeah. Now this is the price I'll pay. Take it. Then there is a conflict of interest, right? Duty not to make secret profit. Duty to remit sums. Whatever money I'm receiving on his behalf, I should give it to him. Duty not to delegate. You already know that. 190 we saw, na? Sub-agent. Exception is there. Properly appointed sub-agent can bind the principal vis-a-vis third party. But agent has no power to appoint sub-agent without the consent of the principal. If he does that, acts of the sub-agent will not bind the principal. Duty not to use any confidential information received in the course of agency against the principal. So we are now going to see a problem on implied or powers of an agent, which is ABC Limited sells its products through agents, and it is not the custom in their business to sell the products on credit. So normally ABC does not sell on credit. Everybody knows in the marketplace, ABC Limited does not sell goods on credit. They do only cash and carry business. Okay. One Mr. Pinto, one of the agents, sold goods of ABC Limited to Mrs. Parole Private Limited on credit. Now, at the time when the goods were sold, Parole Private Limited was insolvent at the time of sale. Has the agent acted prudently? See, let's look at the duties of an agent here. Duty to take reasonable care. Duty to execute the mandate. He has done nothing. He has sold it on credit. Normally, the principal does not sell on credit, and he has sold it to a company which is insolvent. Now, ABC Limited sued Mr. Pinto for compensation towards the loss cost due to sale of products. Will ABC Limited succeed? Yes, they will, because the agent has been negligent. The agent has violated his duty to follow instructions or customs. Normally, this fellow does not sell on credit. He sold on credit. Okay, he has not taken reasonable care and skill. Boss, if it's your own goods, will you sell it to a company which is insolvent on credit? That's all. Miracle question. $1 million question. If it is Pinto's own goods, will he sell it? No. Then how you can sell for ABC? So that is ultimate testing. Will he do it for his own goods? Will he do it? For example, in fact, my father used to do this. I was an article clerk to my father. There were other article clerks. Okay. He used to be harsh on me, where he will be lenient on the other article clerks. He'll be harsh on me. His logic is simple. If it is my own son, what will I do? The same thing I'll do for him also, or little less, but not more. So I will be insulted. I will be told to stay back and do something, whereas other articles will be asked to go. So this was the test my father applied. For my own son, what will I do? That I can do for you, or less, but not more than. If I would not punish my son, how I can punish you? Okay. This is the type of, these things, once you have a clarity of thought, then everything will fall in place. But the clarity of thought is not there. I want to become CA. I want to pass the exam. Then later when we become CA, the ethics will not be there. That is how we find unethical. So clarity of thought is more important. Clearing the exam follows. Okay, clearing the exam happens. But being ethical, prudent, that is the quality of a chartered accountant. Okay, members of our institute, knowledge, prudence, conservatism, ethics. If these are not there, only knowledge, what's the use? Yeah, you are a knowledgeable person, encyclopedia of income tax, indirect tax, GST. So you should be prudent, and you should be conservative, and you should be ethical. Of course, in addition to that, you should also be an authority on the law. Okay, that goes without saying, but this is also important. I know this is, some of you might feel this is unnecessary, waste of your time. I do agree it's a waste of your time, but chalo. Now, one more huge challenge. You know how many slides are there? 78 slides. Which slide I'm in? 40. Another 38 slides are there. It's not going to happen today. So what I'm going to do is, I'm going to stop now. And next class, maybe, inshallah, I will take up the balance of this, then go on to General Clauses Act, that is between me. Today was definitely a challenge because absolutely I could not connect with some of my beloved students like Pooja, Hitesh Jain. I mean, I know you by name, not by sight, and others. If I not mentioned people, it is not because I don't want to mention, because I can't mention everybody. These two names come to my mind immediately. So others are also there, Bandh Reddy, so many people. Sorry, I could not answer your questions today because of technology problem. In the next class, whatever questions are relevant, other than, complaints about, sir, you are not answering my question, that and all I will ignore. Only the questions that are relevant, I will take it and I will answer it. Okay. Thank you and for your patience and understanding of my problems. Wishing you all the very best and looking forward to meeting you again before this session gets over. Bye. Sir, class over, sir.